bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Already sworn in. Thank you.
Thank you for being there.
You're welcome.
I think you have more rep.
Yes. We have Fermin Morales Vasquez.
Fermín Morales Vázquez, pase adelante y póngase los
He
audífonos,
is
por favor.
behavior.
Behavior, Your Honor.
What do we do with that? Public Defender, what do you want to do?
Ray Taylor on behalf of the Office of the Public Defender. Good morning, Judge. I'm getting a bit of an echo here. I'd like to just reset this, please.
El
Reset
abogado
for
de la
tomorrow.
defensa está pidiendo que este caso se aplace hasta mañana.
Is that what you're asking?
Yes, Judge.
We'll reset it for tomorrow.
Bien, este caso se aplaza hasta mañana.
Roseman Martinez Villa Toro.
Guzmán,
Sí. Sí.
yes.
I find probable cause to stay the bond at 500.
PD appointed on each of these, Judge.
I'll point to PD, sure.
Okay.
Okay.
We're good with the interpreter?
Yeah, that was the only.
All right, Madam Interpreter, thank you very much. I want to say goodbye to you.
Thank you, Your Honor. Have a great day.
All right, bye-bye. Still not happy with it. Not happy with this.
Yeah, I can hear a lot of, yeah. I can hear my
Is
echo.
this any better? No, it's too loud. Turn the microphone off.
Need it, because you have to record it. Just see if you can push it up some. Loud.
Hopefully this will be better.
Yeah. Yeah, coordinate.
Okay, sports fans, here we go. Kip Cornelius.
Kip Cornelius.
I'm tearing these off.
Yeah.
Is this Mr. Cornelius?
Yes, sir. Which one the judge, the female or the male? The male, okay, that's, or reporter, okay, female.
I find probable cause.
Like I got $1,000 bond, $100 bond, and hopefully my Johnson, my family, I know your Johnson, you and I know.
It's okay, let the judge talk first.
I'm probable cause and I am staying the bond at 1,000. You're asking for any other relief? I'll appoint the public defender.
All right, yes, sir.
Go, Judge.
He's on.
He's out on bond. What do you got on, what's he out on bond for?
Judge, if I may, the out on bond case, the criminal mischief, he was just returned from the state hospital on that case. He was previously incompetent to proceed. He was just returned on, I think, January 4th and released. So based on that, I'd just be asking you to take no action and leave it to Judge Roach to decide what she's going to do.
Who's got the case that he's out on bond on? Judge Roach? Yeah, I'll take no action on it. Take no action. Jermaine LeVar Smith?
He refused. Jermaine Smith, refused, sir.
I'll appoint the public defender. What do you want to do?
We can waive, Judge.
Pardon?
We can waive his appearance.
To find probable cause, I'm going to stay the bond, including no bond on robbery with a deadly weapon. No return to the scene and no contact with the victim.
I think that's an F1, Judge, but not a PDL. I think you need to have a bond on.
State you agree he's entitled to a bond?
One moment, Your Honor. I do believe as long as it's not a PBL.
I'm sorry?
I'm sorry, I agree that if it's not a PBL case, then he would be entitled to a bond.
Suggestions?
I apologize, Your Honor. Give me just one moment. Actually, Your Honor, robbery with a deadly weapon is a PBL case, and the state would ask for no bond. I apologize for the confusion.
Is it a PDL? Deadly weapon? It's not a firearm?
It's robbery with a firearm or a deadly weapon.
Just take a second and confirm that, and we'll go from there.
Wrong on that. Let's see. Oh, okay. Deadly weapon is a PDL. Robbery with a weapon that's not deadly is an F1. So I'm wrong, but Judge, you could still use your discretion to give him a bond.
I understand that. I think we'll leave that to the trial judge. No bond on count one.
Thank you.
Yeah. Oh, he said the bonds on all accounts. Say the bonds?
Yes.
It was no return to the scene and no contact with the victim.
Gregory Massey. Find probable cause for the DUI property damage. Leave the bond at 1,000. Reported that he consumed no alcohol while out on bond. Who's got his felony case? What judge?
I don't know if I wrote that one down.
He's got a felony case.
It's Division 19.
It's 19, it's Roach. Judge Roche. He's represented by Ollie and Blankner on that case, Judge. I talked to Mr. Ollie briefly this morning and told him that I would, on his behalf, ask the court to take no action on this case.
I'll take no action. I think Judge Rhodes can handle that once she sees him next.
And Your Honor, the state would just ask for no driving without a valid driver's license due to the nature of the charge.
No driving, sir, unless you get your license back.
So no alcohol and no driving.
No alcohol, no driving without a valid license. Those are the conditions of release in this case. You understand? All right. Arthur Terrell Gray. Well, that may not be his, hold on, I think I've got that wrong. It is Arthur Terrell Gray Jr. Is that you, sir?
It should be Mallett.
Just called him off the top of the stack. All right. Mr. Mallett? Okay. Find probable cause, stay the bond at $500, no return to the scene. We have a John Doe, also known as Darian Cortez Phillips. Sir, what is your full legal name?
Damian, Phillips.
What's your middle name?
Cortez,
Your date of birth?
September the 6th, 1989.
Says 88 on your charging affidavit.
Oh, excuse me, 88, excuse me.
Tell me your name again.
What is it?
Tell me your name again.
Damian Alexander Phillips.
What happened to Cortez?
Oh, well, I don't know. I'm sorry, sir. I'm just ready to get out of here. I hear voices.
Yeah, well, you're gonna hear this voice. State, do you have any suggestions about that until we know who he is?
Your Honor,
No, this is important because I want to get out of here.
Hold on one sec. Listen to the judge.
Your
You
Honor,
know, on my ID, they put John Doe.
Your Honor, in all honesty, this is the first time that I've had to deal with this situation, so I'm not entirely familiar with it. I will say that, yes, he is, on the arrest affidavit is John Doe. He told, someone told the officers that he, I guess it was his roommate, that he is Damian Cortez Phillips. We have it on our docket as Darian Cortez Phillips, and then in light of what he's saying today,
Yes, excuse me, Darian Cortez Phillips.
like I said, I'm not familiar with how this situation would typically be handled.
I mean, I just hear voices.
I don't have a question out to you, sir.
I'm ready to get out of here.
I don't have a question out to you.
Let the judge talk.
Let me ask pretrial, how did you determine the AKA? From the charging affidavit?
We just go by what was on it, charge affidavit, and we have Darian, Cortez Phillips.
Has his ID been confirmed by fingerprints? As Damian Cortez Phillips? Yes, sir. To show a date of birth?
We have 9/6/88.
All right. All right, I find probable cause. I stay the bond at $500 per count. No return to the scene and no contact with the victim.
Your Honor, the state would also ask for no weapons of any kind.
No possession of weapons of any kind.
Is the PD appointed on this, Judge?
Point to public defender.
Okay, so when do I get out?
Those are your bonds?
Okay. Okay, so
There's another.
they will give me a release letter now?
Should I call this guy now? Okay.
But wait, where do I get the money from? Or what?
No, so if you talk to people in the back, they'll give you a list of bondsmen who can help you out.
Okay. All right, so I got one more question. Do I just like,
Here, I'll walk with you.
okay.
We have private counsel in the room? All right. The clerk says we've got two more than you, okay?
Okay, thank you, Your Honor.
Yes. Let's get Arthur Terrell Gray Jr. out here. Is that you, sir?
Yes.
All right. Anybody know why this was reset?
Behavior.
Well, as to this case, first of all, I'll appoint the public defender. I find probable cause. I want to stay the bonds at, count one, 2,500, count two, 150. What's he on bond for? Possession of a controlled substance? Who's that pending in front of? Do we know? Judge Wooten?
Yes, Judge.
What's your bond in that case, sir?
This case?
No, in the case you're out on bond on with Judge Wooten.
I'm not sure.
Judge, I pulled it up and he was released on a 33-day motion. State didn't file in time, but they filed shortly after.
I'm gonna take no action, but you're gonna have to see Judge Wooten. That may not go as well for you.
And Your Honor, the state would ask for a no contact, a no return to any scene if there is one, and no weapons.
Yep, no contact with the victim, no return to the scene where this incident occurred. I don't think there's a weapon. Is there a weapon involved in this case, Madam Public Defender?
Not that I recall, Judge. I don't have the affidavit in front of me anymore, but I don't remember one in the affidavit.
Your Honor, there was no weapon used in this incident.
I'm not gonna order no weapons then.
Okay.
I'm sorry? Mr. Ramirez?
Sir.
All right. Find probable cause. Stay the bond at none. Why was he continued from yesterday? Behavior,
A
Medical.
medical.
medical?
Judge, it looks like he has no real criminal history. Would you be inclined to use your discretion and set a bond this morning?
Not on these facts. Take it up with the trial judge. No return to the scene, no contact with the victim.
And Your Honor, no weapons?
No weapons.
You say no contact? No weapon. You have to come to downtown court
I need to pay attention to this.
at 0 for now. Means you can't bond out. Because your bond is 0. You're all set. You're gonna go that way?
Raheem,
Oh, I'm sorry.
Raheem Basks?
Yes.
Okay.
Good morning, Your Honor. Michael Mackin on behalf of the defendant.
Good morning, counsel. I find probable cause.
Your Honor, we request that the standard bond be set. He has no criminal history, so we'd be asking for a bond of $3,500 if the court is so inclined. He has ties to the community, he owns his own business, and he's been living in Orlando since birth.
Prior history state.
One moment, Your Honor. I'm sorry, give me actually. I'm not showing a history. And yeah, I don't think that this is the case where they're from out of state, so I don't see a history.
Domestic battery by strangulation and aggravated battery on a person he knew or should have known was pregnant. Yeah, I don't think I'm gonna set it at 3,500. I set it $5,000 per count. Each count, $5,000 each.
Is the court inclined to set the 150 for the second count, or a little bit lower?
It's $5,000 on each count.
Okay.
The, no return to the scene, no contact with the The victim, which I understand is his wife or girlfriend or the mother of his children, correct?
Right, it's his girlfriend, Your Honor. The only thing is that the police report does show that she was living there temporarily. She packed her belongings. This is actually his house, and he paid for an apartment for her. She's got her own apartment, and she's been living in her own apartment. So we would just ask if the standard no contact order be intact.
Your Honor, the state would ask for separate residences. I believe that when this incident happened, there's children that were in the home, and while she was trying to pack her bags to leave, she was also trying to pack her bags for the children. So I'm not sure how that would affect their living situation.
Well, from what I know, from what my client has told me, he's been maintaining an apartment for her, and she just lives temporarily there while she's pregnant. He helps her out. He has his kids. She has his kids. He has additional kids with another person, and so does she. So she'll live there temporarily when they're kind of like hanging out, and he's taking her to her appointments. But he maintains a separate residence, separate apartment for her. So I think the problem's solved if we put the no contact and no shared residence, and that'll cover it.
I think that is the answer, no contact, and certainly no return to any shared residence.
Your Honor.
Or any residence of hers, yes?
If I may, the state's only concern is that, in light of defense saying that Mr. Bosch, that he pays for her separate resident, he pays for her apartment, and given these facts, the state is concerned that situation he will continue paying for the residence while this case is pending.
You're concerned that he will or he won't?
That he won't, and then she won't have anywhere else to go except for back into their home.
Do you have any authority for the idea that I can order him to continue to pay for her residence?
No, Your Honor. I would just I would ask the court to consider the original condition that he not be allowed to return to the home where this incident happened, in the sense that she is likely, given what I had just stated, that if he does stop paying for her residence and she doesn't have anywhere else to go, she's likely going to have to stay in this same, in the shared home that she was at where the incident took place. Also, without her being here to say that she's not, she doesn't feel comfortable with him returning or him being out, I would just ask the court to consider the original condition of a no return. And in light of the fact that defense has said that he has multiple ties to the community, he would be able to stay with a family member, or friend in a separate residence.
Your Honor, if I may, I think this is intruding a little bit on a domestic relations case. I mean, she's free to file for an injunction or whatever she has to do, and they would address support and paying for apartments and all that type of stuff. But as the fact stands, she has an apartment. It's paid for at least for the immediate term. So she's living there now, and my client tells me she's already packed her stuff, and the house is all locked up so that she can't get back in there because they were in the status of separating anyways.
Where did this event occur?
At his home,
Which is what address?
one on the affidavit, the 2521 Alcobey Circle.
Where's the apartment?
You want to say the address for the apartment?
251 Kent Place, Kissimmee, apartment A.
As a crow flies, how far is it from the residential address?
About 25 miles, and her kid's school is probably 2 miles away from that, which is a lot more better than my area.
Through what date have you already paid for it?
I've paid for her apartment and all of her expenses since the beginning of her pregnancy, so we're about
How
8
far
months.
in the future is it paid for?
Till
Uh,
March, right?
the next 2 months, yes, correct.
I'm going to leave it the way I ordered it. So there's plenty of time for her to get in touch with the victim advocate, Harbor House, and those kinds of arrangements. In any event, the problem is clearly solved by the order that says, no matter what she wants or needs, you're not to have any contact with her, which means it's in your best interest to make sure she has a place to live. It's not required, but it's in your best interest, because if she comes to your doorstep, that's gonna be a problem.
Okay, so no contact and no shared residences, correct?
Do you want maintain separate residence, or do you want do not return?
I don't think I don't think do not return is what's appropriate. It's his residence.
So maintain separate.
Maintain separate residences.
Okay. Thank you, Your Honor.
Thank you, nice to see you.
Have a good day.
All right, good morning to you. Mr. Bragg, or Ms. Bragg, Mr. Bragg. I found probable cause. I set bond on count one in the amount of $10,000, count two, $1,500. On this?
Yes, sir.
I'm not gonna let him have PTR.
And he has no criminal history at all, Judge. Just so you're aware, in case that would change your bond orders.
Yeah, I hear you. Look, we're just not gonna return people committing violent offenses against spouses and girlfriends and victim pregnant people. We're not gonna return them out to the community without some hook into the criminal justice system. I don't think pretrial release is appropriate. You wanna put on any evidence about his financial ability?
Sure, and
Point to public defender.
thank you, Judge. And Ms. Birch is also here in jail. I don't know how court wants to handle that. But Mr. Bragg, does he need to be sworn in?
Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth?
How much money can you afford to pay for your bond?
Yeah, I could afford it. I mean,
So just,
it's two separate ones, right?
so if you had to put up $1,200 cash for your bond, can you afford it?
Yes.
Okay.
Leave the bond at 10,000, count one, 1,500, count two. Now, I was inclined to order no return to the scene. Is this his residence?
No, it was at a hotel.
Certainly no return to the scene then, and no contact with the woman that you had a problem with. You understand?
Yes.
It says here, Madam Public Defender, he does not qualify for the public defender. So I provisionally appointed you for this.
Okay,
I'm gonna have to hire his own lawyer.
I'll make note of that. Thank you.
Thank you. Ms. Birch? Ms. Birch, I found probable cause in your case. I'm set bond at $7,500 in count one and $1,500 in count two. No contact with the victim, no return to the scene.
And Your Honor, is the public defender appointed on that case?
Does not qualify.
Okay.
Provisionally appointed, but you don't qualify.
Does not.
She doesn't qualify.
Thanks. Social Services does the affidavit, so I don't even see them until.
Sure.
Thank you.
Mr. Duran? All right, I found probable cause. I'm gonna set bond on count one at $7,500, count two at $7,500. No contact with the victim. Not on these facts. Thank you for letting me know. Mr. Garcia Ortiz? That's you? Okay. All right, sir, I find probable cause. I'm gonna set bond at $1,500 in each case, no return to the scene, no contact with the victim. Let me look at that. State any information on prior history? Madam Public Defender, he does not qualify for your services.
Oh, thank you.
Provisionally appoint you, though, for today.
Your Honor, I don't see that he has any history.
You mind if I ask him some questions directly?
Sure.
Sir, do you still live with this other individual?
I'm sorry?
You live with the other individual.
I live with him?
Do you live with him?
No.
You live in the same apartment complex,
In a house?
in a house? You live in a bedroom in the house, he lives in another bedroom?
Yes.
So if I ordered that you not return to the scene, you'd have to move?
I have a place to move. I have a place to move.
Right. I think on this, I'll let him participate in the PTR, but no return to the scene, no contact with the victim. Yes. Yeah, he can go back once to get his stuff with the assistance of law enforcement.
You're all set. Good.
Mr. or Ms. Joseph? Yes. All right. Find probable cause. I set bond on count one at $1,000, count two at $5,000, and stay the bond in count three at $1,000. No return to the scene, no contact with the victim. Certainly, I'll appoint the public defender. You want to be heard?
No, Judge, thank you. I was just gonna ask that.
And Your Honor, just for clarification, it was $1,000 on count one, and the second count was 5,000, and then stay the bond at 1,000 for count three.
Correct.
Thank you.
Was there any no contact order?
Yes, no contact, no return.
DCF allows contact? Do you want that to change
Sounds like you do want to be heard.
order? Sorry.
What's the situation?
So my understanding from Ms. Joseph is that DCF has concluded their investigation and closed out any case, which would mean that she would be, pursuant to DCF's order, would be allowed to have contact with her child. So I guess I'd be asking for the court to make its order consistent with any finding in place by DCF or family court.
In the underlying case, how old was the victim? You know,
I don't have the facts in front of me, Judge.
want to ask her?
Sure. 11-month-old baby, Judge.
Is that her child?
Yes.
And you're telling me DCF took no action?
Excuse me, Your Honor. So DCF did take action. They told me I can leave her in the custody of his grandmother and I'm able to get her because I do have full rights to her. It's just me and her father have had an abusive past where I did press charges on him. And because of our past recent history, they told me I can have full custody of her. At the moment, I went to go get her and I had a warrant and I was arrested for the warrant.
So you don't know if they're gonna permit you to have custody after
Yeah,
they
so
find out you got arrested?
So yes, I am permitted to have custody. It's just the arrest was due to the report, and after the report, DCF did talk to me, and they told me I can go there and get her. I didn't know about the warrant, so when I went there to get her with police escort, police arrested me. And my
So it sounds like DCF's investigation happened because of this incident, and then they didn't arrest her on scene, but DCF continued to investigate, and then they submitted the affidavit to issue warrant to the judge.
Where was the location where this occurred?
the location that this occurred was at his apartment, and
Boyfriend's apartment.
at my boyfriend's apartment.
You have your own separate place to live?
Yes, I do.
Okay. So I'm still gonna order no return to the scene.
Mm.
And I'm gonna order no hostile contact with the child. And if you wanna deal with that, you can take it up in front of the judge who will have this case, if it gets filed on and when it gets assigned.
So do you want to strike the no contact?
Yes, no hostile contact. With the 11-month-old child, yes, no hostile contact.
But do you want to strike the no contact condition, or you keep it for?
Boyfriend?
Yeah.
No contact at all with the boyfriend.
Okay.
And no return to the scene.
Okay, so the no hostile is just for the child.
So I should say it differently, that no contact with your boyfriend as it relates to 1 and 2, no contact, no hostile contact with your child as it relates to count 3.
And Your Honor, the state would just ask for the order to reflect that the defendant abide by any conditions of a DCF order.
How are we gonna enforce that?
My understanding is when I was here on Friday, that was an order that was, it was just a condition that was added to the order, and that if a DCF order said that she needed to have supervised contact with her child, then that would be how the situation would work.
I'm not gonna order that. If she
Okay,
violates DCF's directions, they're gonna take the child from her.
okay. Thank you, Your Honor.
Yep, you're all set.
And would the boyfriend, I don't have the underlying facts, would the boyfriend be a co-defendant for counts 1 and 2? Or is it just no contact with him in general?
Not that I could see, but the state
Okay.
might have a no file on him that,
Okay. I'll just keep it as, in my notes, I'll just keep it as no contact with the boyfriend.
Mr. Tademi?
thank you, Judge.
Thank you. With the public defender, I find probable cause. Set bond in the amount of $2,500, no return to the scene, no contact with the victim. Take a look at it. Not with a weapon, not with a knife. I'm not doing it.
The no judge?
No, I did. Thank you.
So the only condition if you want is no contact, no return? Do you want?
And Your Honor, no weapons?
No weapons.
Thank you. And that was no to PTR? That was no to okay.
Ms. Davis? Appoint the public defender, find probable cause. Set bond in the amount of $1,500. All right, let me look at the facts. Can she live with no return to the scene and no contact?
Judge, her name's on the lease. Told that the alleged victim has left the apartment, so I'd be asking for no contact and just maintain separate residence.
All right, I'll let her participate in PTR. No contact with the victim and maintain separate residences. But I'm not gonna order that she not return to the residence that's hers.
Thank you, Judge.
And Your Honor, is that PTR with a bond or straight PTR?
Okay, PTR.
You're all set.
Diaz Martinez.
Yes, sir.
He does not qualify for the public defender. I'm gonna find probable cause. Set the bond at $1,500, no return to the scene, no contact. You're right, I'll make it $750 apiece.
I'm not gonna sign it if I don't know what it is.
You want to take a second to read it?
I have a copy right here.
He does not qualify for the public defender. Thank you.
Judge, I know I'm not appointed, but I heard the court order no contact, and I guess he's having a question about why he has to sign the no contact order paper.
So that he understands what the terms are.
So am I getting a bond, Your Honor?
$750 per count, total of $1,500.
Total 1,500. Okay, so that has to be paid today?
Well, you can pay cash or hire a bondsman and pay their premium,
What would that be?
usually 10%. I think they have a minimum, so it may be $200, but I'm not involved in their business. I'd be happy, they're happy to keep you if you'd rather not have a bond.
No, no.
Ms. Haynes,
Hi.
doing? This one does? Let me take a look. I find probable cause, I'll let her participate in PTR. She qualifies for the public defender, I'll appoint the PD. I want to be heard, I want to hear some circumstances about no return to the scene and no contact.
Thank you, Judge. No, that's okay.
He was there at my house.
All right, Miss Haynes leases the property, Judge. Her name's on the lease. Her son's name is not on the lease, and he does not live there. He should not be there. We can probably accomplish what needs to happen with no contact and maintain separate residence.
I'll order that you have no contact, this happens to be your son?
Yes.
So no contact means no phone contact, no texting, no social media. So, and it's your responsibility, even if he says, oh, mommy, 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 I want to talk to you.
Yeah.
You can't talk to him, you understand? How old's your son? How old is your son?
He's 25.
I got a 25-year-old son. I don't think there's any way my wife would not answer the phone if he called. You understand how hard that will be?
I do know, but he fixed something up that can't be replaced, that has personal stuff on it and broke it. So that's unfortunately what caused me to snap.
You'll be the one that goes to jail if you have contact with him, all right? Ma'am?
Yes.
You'll be the one that goes to jail if you have
I
contact.
understand that.
All right.
Yep, I'll never be here again. Don't worry about that.
No contact, separate residence.
No problem. Thank you.
PTR. No, you're gonna get released out.
Johnson? Find probable cause, public defenders appointed. Pretrial release apply? Does not qualify. Set bond at $1,000, no return to the scene, no contact. Mr. Murillo?
And Your Honor, the state would note that I believe this is the victim, and she's here.
In this case, in Anthony Joseph Murillo?
Yes.
Yes, you can talk to him. Straight.
Ma'am, raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Public defender is not appointed, you do not he does not qualify. Ma'am, what is it that you want me to know?
I just,
I can't hear you.
he's a good person.
Be closer to the.
Oh, I'm sorry. Is this better?
Yes.
Okay, I'm sorry. He's a good person, and I would like to keep contact, and,
Okay, let me ask you some specific questions, because we have a range of alternatives. First of all, I find probable cause that the offense was committed. So I'm gonna set bond at $1,000. Now, I can order him to not return to the scene. What was the scene?
we were in our neighborhood, in a car.
Okay, are you comfortable with him coming home?
Yes.
I can order no hostile contact with you. Is that what you want? No fighting, no arguing?
Yes,
You want him to be in the same house?
yes.
All right. Is there anything else you want to tell me?
Not at this time, no.
Okay. I'm gonna tell you what I'm gonna order. If he's got $1,000 bond, he can come back home, no hostile contact with you. Is that
Yeah.
enough for you?
Yes.
It's terms of your release, sir. Mr. Neal, Jason Neal,
Mental health, Your Honor.
this young, Mr. Neal is out at mental health?
Yes, sir.
Guess we were setting. Public defender is appointed.
I'll waive his appearance, Judge.
I'm inclined, I find probable cause. I'm inclined to set bond at 1,000, no return, no drugs or alcohol, no contact.
Sounds good.
Mr. Pittman.
And Your Honor, the state would note that the victim is present.
On Mr. Pittman's case,
Are you here for Mr. Pittman?
Yes, sir.
Yes.
just speak close, she's gonna swear you in, but get close to the microphone.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
What was it you would like for me to know?
He is my boyfriend. We've been together for 11 months.
I can't hear you. You gotta get really close. You can take your mask off in there, okay?
He is a really good person. We've been together for 11 months. Yes, we are homeless. We've been going through some stuff, going to the streets, sleep on the streets. We supposed to be going to Atlanta today to live with my uncle, but I'm not for sure if he gonna get out or not before we can go back and live with him and get our feet together. This incident, it was a accident. Like, couples gonna argue and fight and stuff like that. Like, all the stress that we've been going through, we just took it out on each other. And this was just an accident right here. Like, I didn't know it was gonna come out in this right here. Like, I really do love him. He really do love art. He do want to go to school for art. I can say that. He loved doing clay stuff, animations. He do want to work at the CNN network company for adults. So he do want to do that, and I'm just here to support him and whatever it takes.
Okay, thank you. Is that all you want to tell me?
Yeah.
Okay. Does this individual qualify for pretrial release? No, sir. All right. I find probable cause, Mr. Pittman. I'm going to set your bond at $1,000. I'm going to order you to have no hostile contact with the victim, this woman right here. Do you understand? As soon as you post your bond, I'm going to give you permission to leave the state to live with her uncle only. You can't go up there and not live with him. You can't move to Atlanta. But if you can find a place to get off the street, I'll give you permission for that. You will need to appear at every scheduled court appearance for this, either in person or through a lawyer. PD's appointed. So you'll need to make sure that you stay in contact with their office, because sometimes they can appear in court for you. But it's going to be hard for you to appear in court here from Atlanta in person. Do you understand that? And if you fail to appear, I'm sure the judge who gets assigned to the case will issue a warrant for your arrest, which will only complicate your situation. You understand? All right. I don't want you to be on the street, and if this is a legitimate way to get off the street, I'm gonna let you take a shot at it, but don't forget this court obligation.
Sure.
All right. Can you post a bond of $1,000? You'd have to pay a bondsman $100 or $200. All right.
Well, he's asking.
Oh, not right now.
How long would it take you to raise that kind of money?
Not tomorrow, for a couple of weeks. I just got a new job.
You can't get a job while you're in jail. Ma'am, how long would it take for you to raise $200?
Not that long.
How much is that? Just tell me how long that is.
It'll be like less than a week.
You've got someone who can loan it to you, or you can work for it?
Yes.
I'm gonna reduce the bond to $500. So but I still think your premium is gonna be $200. Bondsmen have some sort of minimum, but that's the best I can do for you. Good luck. Don't fail to appear. Do not fail to appear.
Your Honor, if I may inquire, is there a way for us to get this uncle's address on the record in case we fail to appear?
You know your uncle's address?
He just moved, that's the thing.
Got to speak into the microphone.
He just moved, so I don't know it.
Do you know her uncle's address?
Okay.
They'll just have to give it to the bondsman when he bonds out.
Well, I smell a failure to appear coming, but that'll be on him.
I wrote down the specific extension he'll need for our DV unit.
All right, thank you. Leonardo, can't say it. Say your last name.
Castillo Cruz.
Castillo Cruz.
He's first on the felony docket.
Okay. This is not him.
Did Leonardo?
I don't have him on my paperwork. Leonardo, you have him on your paperwork?
200, 1746.
Yeah.
Thank you.
Okay.
You'll have to.
What's your name, sir?
Edwin Armani Castillo Cruz.
Gotcha. Public defender is appointed. I find probable cause. He's here on a warrant from out of county. There are 3 cases. Let's take them one at a time.
It's gonna tell me.
Right there. Gotcha. All right, I find probable cause on the charging affidavit that charges possession of methamphetamine, grand theft, third degree, possession of burglary tools, and criminal mischief. I'll stay all of those bonds. I find probable cause for the violation of probation on the second case.
That's the out-of-county case.
That's the out-of-county case. That judge that's in Seminole County, where apparently you were on community control.
Yes, sir.
Okay. What was that offense for? Grand theft motor vehicle?
Yes, ma'am.
Yes, Your Honor.
I want to keep the bond at no bond on that charge. So you have bonds in all your Orange County cases? No. And he's on bond on this case? I'll take no action on that.
Your Honor, I do have a newborn out there.
Yeah. Probably should have thought about that.
And Your Honor, for the Orange County cases, the state would ask for a, I don't think we could do a no return, but no drugs of any kind.
Sure, I'll order no consumption of any illegal drugs or drugs not prescribed to you on your Orange County cases for which you have bonds.
That's the only condition.
Yes. Susan Dalby?
Yes, sir.
You have 3 cases, so I'm going to take them one by one.
Yes, sir.
You were arrested on yesterday, 1/22, apparently,
Yes.
for aggravated assault with a motor vehicle and grand theft motor vehicle. I'm going to stay the bonds on those. I find probable cause, stay the bonds on those charges at $2,500 and $150. I'm going to order no contact with the victim. Public defender's appointed, by the way. You were also arrested yesterday, charged with possession of fentanyl, possession of cocaine, and possession of drug paraphernalia. I'm going to stay the bonds at $1,000, $1,000, and $500. Find probable cause. Order that you consume no drugs, no illegal drugs, no drugs that aren't prescribed to you in that case. You were also arrested for DUI. Yesterday. Find probable cause for that arrest and all 3 charges. Stay the bonds as stated in the charging affidavit at $500 per count. Don't drive without a valid license. All 3 counts in this case.
Okay.
Do you understand?
I do.
Have any questions?
No, sir.
Thank you.
So how much is straight?
Set them all at 500. Yeah. Mr. Marine, What's your name?
Right here.
All right. Public defender's appointed, find probable cause.
Excuse me, sir. I mean, interrupt.
Let him talk first and then.
I want to represent myself. That's why I want to let
Okay.
talk. That's all. I ain't mean to cut you off, but I would like to represent myself.
You do?
Yes, sir.
Okay. Well, I'm going to appoint the public defender anyway as what we call standby counsel for this proceeding. I'll let you speak on your own behalf, all right?
I mean, I don't want the office of public defender to represent me, period, if it's okay. I will represent myself.
Okay, that's fine.
Thank you.
Public defender, you're relieved of your responsibility. I find probable cause, bond stayed at 1,000 in count 1, 150, count 2, $100 in count 3. No return to the scene, consume no drugs, no illegal drugs, and consume no drugs that aren't prescribed to you while you're out on this case. Thank you very much. So he's out on, this one's out on probation at 2 separate. For what? Out on bond at 2 separate.
They only do that
Mr. McFadden?
Sir.
On your new charging affidavit, of where you're charged with aggravated assault, grand theft, and battery, I'm gonna find probable cause. I'm gonna stay your bonds as stated in the charging affidavit. 2,500 is to count 1, 150 is to count 2, 100 is to count 3. Order that you not return to the scene and no contact with the victim. Well, just hold on, you've got open cases that you're, just let me look at this.
Just to let you know, Judge, the felony where he's out on bond, Division 16, that case is not filed on.
What's the arrest date, 11/18? I see it now. I'm gonna revoke his bond in that case. Yeah, the felony. It's the same offense alleged, not saying he's guilty of it, but I'm gonna revoke his bond. The judge in that case, you'll be able to apply to have it reinstated with different conditions or with similar conditions. I'm gonna set it at none.
And what about the traffic case?
I'm not gonna take any action on that. Thank you for asking.
Is the PD appointed on the out on bond case if we aren't already?
Yes, I'm gonna appoint you on the current case. There was someone identified as counsel on the case where I revoked his bond. Tamara
Okay.
Green?
Yeah, I think we were already appointed on that one.
Okay.
Thanks.
And Your Honor, I'm sorry, I didn't hear you on there's the 2020 CT 1127. You said you're taking no action on that? That's
Yes,
the other,
I'm taking no action on that.
okay, thank you.
It's a de minimis offense.
Okay.
All right, Mr. Montgomery? All right, let's dive into this. Hold on a second. Appoint the public defender. All right, you've been arrested on a warrant for failing to appear in a misdemeanor, no valid driver's license case.
Yes, sir.
Says you failed to show up for a pretrial conference. There's a bond on that of $1,000. I'm gonna stay that bond, leave it as it is. You're also out on bond on a charge of burglary to an occupied dwelling and a battery. Failed to appear apparently in that case. No, sorry, got ahead of myself. You also have a possession of a controlled substance charge from yesterday on an outstanding warrant from Orange County with no bond. I'm gonna stay that at no bond. Where is new charges? So you have $1,000 bond on the failure to appear, but no bond on the drug charge for which you failed to appear. Burglary to an occupied dwelling, I'm gonna revoke his bond on that.
Judge, I don't think,
Did I get it wrong?
yeah, I think the out on bond case is his newest one. I don't think he committed a new law while he was out on that. I think he just FTA'd on 2 out of his 3 cases.
We're checking on it. Can you confirm this is the last in time? All right, so let me be clear. On the failure to appear for the traffic charge, there's a bond of 1,000, we'll stay that. For the failure to appear on the possession of a controlled substance charge, revoking his bond, or there's no bond in that, I'm gonna stay it. On the burglary charge where he's been out on bond and hasn't yet failed to appear, I'll take no action on that. This is a necessary tool, isn't it?
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Oh, we got a new, anybody, Mr. Morse?
Sir, Your Honor, may I speak?
Why don't you hold on a second? I'm gonna appoint the public defender.
Yes, sir.
Let me see if I got this right. He's on bond for resisting arrest without violence in 2021 MM 524 AA. He has a new law violation, or he was arrested on a warrant for possession of cocaine with the intent to distribute, possession of a weapon or ammo by a convicted felon, and possession of drug paraphernalia with an arrest date of yesterday, which appears to have been based on an arrest warrant issued in November.
Same case.
Yes, I understand. The arrest warrant that was issued in November led to your arrest on it yesterday.
Yes, sir.
The judge who issued the arrest warrant ordered no bond on counts 1 and 2 and a $100 bond on the misdemeanor. State, I don't think I can hold him on no bond on those charges.
Yeah, and I don't believe so. I believe he's entitled to a bond.
Suggestions?
One moment. Yeah, and I'm trying to look up what the suggestion is, but
I'm inclined to set it at $2,500 per count. Let me ask this question, it'll be more easy to answer. Do you object to that?
Your Honor, it seems like our suggestion, and based on what I saw at yesterday's IA, is a $10,000 bond. We would be objecting to a $2,500 bond and ask for at least a $5,000. And that's on
count one?
on count 1, yes, with the intent to sell manufacture.
All right, I can solve that problem. All right, sir. As it relates to your arrest from yesterday, on the warrant that had been out for a while, I find probable cause. I'm going to set a bond of $10,000 on count 1, $1,000 on count 2, and the bond is already set at $100 on count 3, and I'll stay that bond. I'm not going to take any action on the case that you are out on bond already. That's the resisting arrest without violence. Now, you want to comment on all of that?
Yes, sir.
Okay, what would you like to tell me?
Your Honor, I have no, I've been staying in this community for 30 years. I'm 30 years old right now, and I just recently got out of prison for a trafficking charge. As you can see, I've been doing great. I have a job at Olive Garden. I've been going to work. I've been working for multiple record companies. Right now I'm working with QC. I just came from Atlanta, Georgia. Now I'm working with QC. I'm going on tour. I've been trying to change my life. I have a 3-year-old daughter. Her birthday is in 10 days. And I'm going through a hardship at all of this. I haven't even been out of prison for a whole year. I'm going through a hardship, and I keep being taken to jail, harassed every other night. These officers not even reporting all the other incidents they're running into me with. They're only reporting. Yes. Well, the whole thing is, I believe that's a little high for me to pay that bond. I mean, I could try to get it. I mean, my family members, the people are not believing in me no more about me being a great person in life. And so no one is trying to help me out, and I'm going through a very, very, very hardship that's trying to become a great citizen in America. And
So I think the primary issue, I think, is that whether we're talking about 2,500 or 10,000, really it's just how much is coming out of his pocket and away from his daughter and his family. Because ultimately that's just a premium that's going to the bondsman. So whether the bondsman makes $250 or $1,000, it's not going to change his appearance or non-appearance in court. That's a fee that he's never getting back. So the more that we're charging him, the less his daughter's getting for her birthday, and the less that his family is getting.
So if you have a daughter who's going to turn 3, right?
yes, sir.
I have a granddaughter who just turned 4. That's something you should have been thinking about while all this was going on. The bond stays as indicated. I appreciate your hardship, but don't come in here and tell me with 2 crimes pending that you're doing good. You're not doing good. You need to do better. The bond is, as I said. I see that. I'm not going to take any
Yes,
action.
sir.
Oh. Wait a minute. I misunderstood. There's another case. Hold on. You want to? Oh, and the clerk points out to me that there is a new charge of resisting an officer without violence from date of arrest yesterday, 1/22, bond at 500, I'll stay that bond, I'm not gonna change that. All right, thank you.
Your Honor, for if it wasn't imposed under the original warrant, the state would ask for the,
Time out, hold on, this is the. Judge Snow. Yes. Well, I can't, I'm on the bench. I am on the bench. Best estimation of finish is 2:30. Call back from then. Thank you. I can't take a call right now. I'm on the bench. Thank you, Glenn. I'm sorry, I have emergency duty this weekend, and that's the line they call me on. All right, where were we? What happened?
yes, Your Honor, if it wasn't already as part of the underlying conditions, the state would ask for no weapons of any kind as well as no drugs.
Possess no weapons of any kind, no drugs, no illegal drugs, and no drugs not prescribed to you. All right, thank you, sir. Mr.,
So how much is my bond amount?
can you add it up?
I think I did. 16.
I have a, yes. It should be 16-1.
Okay, yeah, 16.
No, I'm sorry, that's wrong. It's 11.
Yes.
11,600. I flipped the 6 and the
You're
1.
gonna need a little over $1,000.
Because it's 10,000 on count 1, 1,000 count 2, 100 on count 3, and then on the resisting without, it's 500.
Thanks.
Mr. Resendez?
Sir.
You have a bond, sir. I find probable cause, a bond is stayed at $2,500. No return to the scene, no contact with the victim.
Your Honor, no weapons?
He's out on bond in another case. I'll order also in the new arrest, possess no weapons of any kind. Out on bond in a new case, trespass. Is that an Orange County case? I'll take no action on the trespass. PD's appointed. Nope, sorry, you don't qualify, man. He doesn't qualify. All right.
Oh.
You also, this gentleman, Mr. Sinclair? Okay. Public defender, he doesn't qualify for the public defender also, they tell him. All right. In the case where he's charged with driving with a license suspended or revoked on a third or subsequent offense, DUI, and leaving the scene, I find probable cause. He's got bonds set in those cases at 2,500, 100, and 100. As you move down the counts, I'll stay those amounts. In a subsequent case where he's charged with aggravated fleeing and eluding, I find probable cause. For some reason, the officer indicated no bond, that he's entitled to a bond unless somebody knows something I don't know.
No, Your Honor.
Suggestion, State?
Your Honor, the state would be fine with a $100 bond.
You think it should be 1,000? It's a separate offense, right?
The aggravated fleeing and eluding, or attempting to elude?
Yes. I'm not gonna set it at 100, but I'll set it at 500.
That's fine, Your Honor. And, Your Honor, the state would just ask for the traffic violation, the DUI, No operation of a motor vehicle without a valid driver's license, and no alcohol consumption.
All right, sir, in addition to having to make bonds, you can't drive without a valid driver's license, you understand that?
Sir, I didn't know my license was suspended. I go to work every night.
Well, this is not the place to contest your charge. And you're not to consume any alcohol. Thank you. Yeah. You ask a lot of questions. They're pretty good, too. You're pretty good. Mr. Smith?
Yes, Your Honor.
All right, well, the new offense is a burglary of a structure and a petty theft. The bond, there were bonds set on those offenses at $3,500 and $100. I'll stay those amounts. Public defenders appointed. I find probable cause.
He's out on bond, Your Honor, for 2 cases.
I see it. He's out on bond in Division 22 with an arrest date of 8/27/20 for 5 different burglaries of dwellings and 5 different petty thefts. And he's out in another case with the same arrest date, 8/27/20, for another count of burglary of a dwelling and petty theft, for which he has posted bond. State, I find probable cause. I'm looking for input on what we should do on the cases he's out on.
Your Honor, I didn't have any of those underlying facts. I'm trying to pull them up now. Unfortunately, there's a lot of Robert Smiths. So.
Okay, well, let me
Judge,
ask the public defender what she thinks. Go ahead.
Thank you.
Oh, thank you, Judge. I would just ask that you take no action, and they're both in front of Judge LeBlanc, and just let him decide how he's going to handle going forward.
And Your Honor, the state wouldn't have an objection to taking no action.
Okay, take no action. No return to the scenes of any of the offenses listed in your new arrests.
Understand, Your Honor.
Gotta stay out of other people's places, sir, other businesses. Mr. Young, or Miss Young?
Thank you, Your Honor.
Yes, sir. Public defender is appointed for Miss Young. I find probable cause, bond stayed at 1,000 in count 1, 500 count 2, 2,500 count 3. That's it.
You go back there, and then stay in touch with the court and check on you.
Mr. Webb? Mr. Webb is here after having been arrested on a warrant out of Orange County.
I
Failed to appear for arraignment on a charge of disorderly conduct.
had my ID run. I had my ID run by an officer. I didn't do anything wrong. It was by a bigger officer. He checked me, and I'm here because I was sleeping. A cop woke me up, and he just ran my ID, and I cooperated.
Well, that's not why you're here. You're here because you failed to appear for your arraignment. I find probable cause for that. The bond is already set at $500, and I'll stay that. You want to be heard on any of those issues?
I don't know what I'm being charged of. My charges were dropped. I was arrested for
Okay, hold on.
walking across the street.
Hold on. Well, let's see if we can confirm that.
Judge, usually the MO cases are charged as disorderly, but under this statute, or subsection, it's panhandling.
21 MO 1343.
He was ROR'd at IA, and the city later filed on the case. So I would propose, if the state would be willing to offer withhold and time served, we could resolve it today. You okay with that?
I don't know, I mean, am I getting out?
Yeah.
Okay, I'll just do that.
You'd like to do that if the court would take the plea?
Your Honor, I would normally offer the credit time served. However, with this being the underlying charge and the failure to appear, and they just recently then filed on it, well, I guess the information was filed on the 8th. My understanding is that would resolve the disorderly conduct. I'm not sure how the failure to appear would be resolved. I would ask that this be resolved in front of Judge Bain, that they can handle that failure to appear.
He's not charged with failure to appear. It's just he's charged with panhandling, and he didn't come to court, so they issued a warrant to pick him up.
Yeah, I
But
understand.
He's not,
Here's what we're trying to confirm. It'll solve itself. Let me just find the sound. Is the disorderly conduct charge still alive? Yes. Okay, it has not been dropped.
correct.
Okay. Then I'm gonna leave his bond at $500 on that. If it was Judge Bain, he set a bond on the capias of $500. Not gonna disturb it.
I understand. We just would,
I would take his plea, but you wanna just plead to the bench? I don't think he can plead to the bench on the underlying offense, do you? He's not here for it.
he is,
He's here for failing to appear on that charge.
if the state's willing to time serve him,
I don't need their consent. I need to know that I can take his plea on a charge that he's not here on.
I'd like to know what I'm being charged for. What panhandling? I was walking across the street. I got arrested.
I'm not gonna take his plea. I'm not sure he understands why he's here. I think it'd be dubious at best. How much lower can we go from $500? You want to ROR him on a case he failed to appear on?
well,
He was just sleeping and I woke up.
I understand the dilemma, Judge, but I don't know that holding him for another 30 days in jail for panhandling is the answer either.
And Your Honor, the state would note that the hearing in front of Judge Bain will be on Wednesday. So he would be able to resolve it in the next 3 days. It's on the 26th.
No, he wouldn't, because he'll be in quarantine, and they won't transport him downtown.
Is that right?
He'll be in jail for at least
14 days.
another 15 to 20 days on this.
He'll actually come back in 3 days to do an in-jail arraignment here at the jail, unless something happens within that time and he's in medical. But it's in jail, he's not going down here.
All right, state, be prepared in 3 days to make an offer. You don't have to make an offer they want you to make, but you need to be prepared.
Okay, I'll make a note of it in his case.
And it'll be Judge Jewett next week.
Okay? I'm sure it'll get resolved with under those scenarios.
I just want to know what I'm being charged of.
You really want to go through this? You failed to appear for court. The judge issued a warrant. You've been,
I was here. I called.
just take him down the hallway and explain it to him, please. Can I throw that in there for you? Is that, we don't need to look at these? We need to get moving those, don't we? Ms. Fish? No, am I not the right? We're Damon Hamilton Fish. Nope. Bond?
Cheryl, the inmate number is 2200-1733.
Angelica Mo? Angelica Mo?
Damon Fish, Fish. I'll put him to the,
Oh, he's mental health. He's mental health.
so. You can either reset it or.
I'll appoint the public defender. You waive his appearance?
Yes, Judge.
All right, I find probable cause, stay the bond at $500 for the one count of driving the license suspended. All right, Miss Mo, I find probable cause to support the charge of driving while license suspended or revoked. The bond is stated $500. You can bond out if you have, can you hire a bondsman for $500?
I'm trying to.
Okay. Don't drive without a valid license.
Excuse me?
When you get out, do not drive without a valid license.
I'm working on it. I already wrote a letter to the judge, which was, I was told. Write a letter to the judge, they received it, so I'm just waiting.
The judge is probably not going to be able to fix your problem. The problem probably rests with the Department of Motor Vehicles.
Oh, that's what they told me. I have to write a letter to the judge.
Okay, good luck. Thank you. Sagerman? Sagerman,
The judge is asking you his name, your name.
what is your name?
Lozada Christopher.
Say it again?
Christopher Lozada.
Christopher
Still can't understand you.
Christopher Lozada.
Rosado.
Christopher Rosado.
Lozada.
It's LOZ.
Okay,
So St. German bonded? Huh? I'm looking up St. German now. And then Fletcher is bonded too? Yeah, Fletcher is bonded too. Thank you.
all right, Mr. Lozada, you're charged. This is a misdemeanor.
Yes, Judge.
Yes, Your Honor.
I find probable cause from the facts stated in the charging affidavit. Your bond is $500. I will stay the bond and order you not return to the scene of this situation.
And was the public defender appointed, Your Honor?
Public defenders appointed.
Thank you.
Looks like. Last name of this young lady?
Buchanan.
Say it again?
Buchanan.
Yeah, there's a couple then that must have bonded.
Richard Samuel?
Samuel's in the hospital.
Yes, reset within 24 hours from release from the hospital. Begley?
Begley's medical.
Point to public defender. Are you willing to waive his appearance?
Yes.
Find probable cause, it's on a warrant, but there's a bond on it of $323. I'll stay that amount. Yeah. Do the same thing on the other one. Find probable cause, stay the amount on Mr. Begley's second case. And now we have Chelsea Buchanan.
Did you say Begley was hospital or?
Bagley was, yeah, medical.
Okay.
He's on a precautions respiratory.
I'm sorry, Your Honor.
Okay. All right. Ms. Buchanan, I find probable cause, you're here on a warrant out of, was it Volusia County? Out out of Volusia County. They've asked for no bond. The underlying charge is fleeing or attempting to elude. I think with that statute number, it's a misdemeanor. Madam Prosecutor, can you help me out on that?
Yes, Your Honor, I will,
901,
901.04.
1504.
I believe it's I'm trying to look it up, but I believe it's a misdemeanor.
Well, let me see if they have the warrant, I can tell by the case number.
Because I don't have any of the underlying facts.
Where do you see that? BLP. But it's not gonna matter now. The underlying offense was fleeing or attempting to elude, but she's wanted on an allegation that she violated her probation. So as I said, I'll appoint the public defender, find probable cause, and leave the bond, stay the bond at no bond. You can, when you get back to Volusia County, you can take it up with that judge. Mr. Guillaume? Is that you, sir? How do you say your name? Okay, thank you. Sir, you're here on a warrant out of Okeechobee. Failure to appear for arraignment. The underlying charge is a DUI. The judge has asked for no bond. I find probable cause based on the issuance of the warrant. I stay the bond at no bond. You'll take it up with that judge when you get down there to see him. Jason Hollenden. Jason Hollenden? Yes, sir. All right. So you're here on an out-of-county warrant, which is from Seminole County. Judge Culver issued a warrant for your arrest and set bond at $1,000. So I'm going to find probable cause based on the issuance of the warrant, stay the bond at $1,000, which means for whatever reason he issued the bond, you can still get out of jail by posting a bond of $1,000. Do you understand that? All right. Take no further action. Eddie Peterson.
Mental health, sir.
Appoint the public defender. Got out-of-county warrants. Find probable cause. He has bonds, as listed in the charging affidavit. Let me make sure here. Waiving his appearance, Madam Public Defender?
Yes, Judge.
All right, I'm just going to stay the bonds as indicated. I think he just has one case. Yes. 2,000 in one count and 500 in the other two counts. It's pretty fortunate for an out-of-county warrant.
Wasn't surprised.
Joshua Rodriguez,
Mental health, Your Honor.
appoint the public defender. You want to waive his appearance?
Yes, Judge.
He's in on an out-of-county warrant for failing to appear on charges of resisting without and trespassing. Let me see where this is. Out of Lee County. I'm going to stay the bond at no bond. He can take it up with the judge in Lee County. Christopher Roth. Okay. All right, you, sir, are here. You picked up on a warrant from an out-of-county, Marion County. Says it's a felony bench warrant for failure to appear at trial. I find probable cause based on the issuance of a warrant, stay the bond at no bond. You can take it up with those people up there.
Law, like L-O, law. Oh, Buck law, okay.
Mr. Towns? Yes, Towns?
Yes.
All right, sir, it's your lucky day. You've been arrested on an out-of-county warrant from Polk County, but that judge has set a bond at $500, so if you post bond, you can get out of jail. I find probable cause, appoint the public defender, and stay the bond at $500.
I'll explain it to you in the back. You're good.
Jeremy Emil Reynolds.
He refused, Your Honor.
Appoint the public defender. You waive?
He was, reset from yesterday. Yes.
Okay. Find probable cause. I'll stay the bonds at $5,000 for burglary of a structure and $150 for grand theft. No return to the premises. Cody Christopher Siegfried. Went to public defender. Find probable cause. Why are we here? This was reset from yesterday, for what reason?
Medical, Judge.
Okay. All right, Mr. Siegfried, you are charged with possession of an amphetamine, possession of cannabis, and battery. Your bonds are $1,000, $500, and $500. I'm going to stay those bonds amount.
I had prescriptions.
Pardon me?
Sorry to interrupt. I had prescriptions for what I was picked up for.
That's a defense you can raise in the trial court. You have those bonds. I'll stay those bonds. Good luck to you, sir. Hope you get out soon.
Your Honor?
Where is that? Hold on, we got more to deal with. Just hang tight.
And Your Honor, the state would ask for no drugs and no contact.
All right. Let's stay on the first charge. No possess any illegal drugs, drugs not prescribed to you, have no contact with the victim of the battery.
And a no return, Your Honor. This happened at a Queen of Pawns.
No return to the premises. All right, so you also have two cases for which you are already out on bond. So let me look at this. I take no action on the criminal mischief.
Which is that the MM case?
It is the MM case. You've got Matt Olszewski as your lawyer?
Yes, sir.
Okay. PD's probably not appointed then.
In the CF case, he has a private, and in the MM case, the 21 CF 14562, he has a private, and 2022 MM 48W, he has a private.
Right. Mr. Olszewski also represents you in, you have possession of a firearm in the commission of a felony, possession of meth, possession of a controlled substance, possession of cannabis with the intent to distribute, and possession of drug paraphernalia. Who is that case in front of?
Which one?
The felony that he's out on bond?
Judge Alvaro.
Yeah. I'm going to revoke your bond in that case. No bond on all those charges, each one.
At all for all of them?
Good luck. Excuse me?
You took away the.
On the case in front of Judge Alvaro that you're on bond, I'm revoking your bond on all of those charges in front of Judge Alvaro for being arrested while you were on bond. I did not revoke your bond in your misdemeanor case that you're out on bond on. Just let Matt Olszewski know what's going on. He knows what to do.
And Judge, sorry, was the PD on the new case or he didn't qualify?
I thought you were.
Yeah, I think you appointed.
I did appoint you on that.
Because it was a reset from yesterday?
Yeah. Or you, yeah, or she was already appointed. All right, Stephen McCarter,
Yes, sir.
public defender's appointed, find probable cause. Bond is set at $250. I'll stay that bond unless,
And Your Honor, for these cases, we would offer the credit for time served.
credit for time served.
Yes, sir. He'd like to do that. Read over one of these in the back?
Yes, ma'am.
All right.
He has 2 days.
No, ma'am.
Are you?
Ma'am.
Okay, because it's.
Do it.
I just want to make sure.
Yeah, that's fine.
Line right there. Need any more time to read this over?
No, ma'am.
File any motions on this challenging the legality of the statute? Okay with that? Can I just go through this?
Yes, ma'am.
Thank you.
You ready?
Yes, sir. Yes, Your Honor.
All right, state, raise your right hand. Is he under oath already?
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Tell me your full name.
Stephen Christopher McCarter.
Okay, you're gonna have to speak up or lean your head down into the microphone.
Stephen Christopher McCarter.
I have an arrest report here that identifies someone as Stephen McCarter. Do you know who that person is?
That's me.
I didn't hear you. All right, sir, your lawyer has handed me a form that says that you want to change your plea from not guilty and enter a plea of guilty or no contest to the charge of disorderly conduct, a second-degree misdemeanor. In this case, it's an ordinance violation of the city, and be sentenced to time served. Is that what you want to do?
Yes, sir.
You understand you could have a trial in this case?
Yes, sir.
You have a lawyer appointed for you. The lawyer could subpoena witnesses, gather discovery. You could have a trial with, probably not with a jury, but you certainly could have a trial where the state would be obligated to prove your guilt beyond a reasonable doubt. You understand that?
Yes, sir.
You could testify and the jury, the court would accept your testimony the same as any other witness, or you
Yes.
could elect not to testify and the jury or the court would not consider that any differently than any other witness, or would not consider that against you. Do you understand that?
Yes, sir.
You suffer from any mental or emotional illnesses?
No.
Did you read this plea form?
Yes, sir.
You satisfied with the resolution that your lawyer has crafted for you?
Yes, sir.
I'm going to accept your plea. I'm going to find it was freely and voluntarily entered, that you're alert and intelligent, and you understand the nature of your rights, and you're freely and voluntarily waiving those to go to trial. I'll withhold adjudication, impose a sentence of time served, which clerk advises me is 2 days. Order your release today unless you're being held on any other charges. Is that what your understanding is going to be?
Yes, sir.
That's what it is.
And Your Honor, is that a no contest plea?
Yes, ma'am.
No contest plea will be entered.
Thank you.
Anything further?
No, Judge, thank you.
There are some court, hold on, sir. Have him come back. There are some court costs associated with your case. You'll get a paperwork that outlines those. I'll give you a year to pay those off. Do you understand that?
Yes, sir.
All right, you have the right to appeal. Any appeal you take must be done in writing. If you can't afford a lawyer for your appeal, one will be appointed for you. Good luck to you, sir.
Have a good day.
Thank you. Strother?
Good morning, sir.
Good morning.
How are you?
I'm fine. I find probable cause. The bond is set at $250, which is the bond appropriate for this. Is there any camping?
Yeah, Your Honor, this is also it's the same. These next cases, this one and the following one are all credit time served.
If you'd like to resolve it, Judge, we have a plea form here.
All right, let's go. Thank you.
Thank you. Yes, sir.
I am going to appoint the public defender. You'll eventually straighten me out, but right now. All right, Mr. Strother,
Yes, sir. Yes, sir.
you understand that the sentence that your lawyer has negotiated is a time-served sentence. You'll get 2 days credit for the 2 days that you've served. You'll be released today unless some other charge is holding you. Do you understand that?
Yes, sir.
All right, did you read this form?
Yes, sir, I did.
Sign it?
Yes, sir.
All right, do you understand we're not going to have a trial?
Yes, sir, that's fine.
At a trial, you would have the right to have your lawyer cross-examine witnesses. You could subpoena your own witnesses. You
Understand.
have the fact finder be required to find by the state's evidence that you were guilty beyond a reasonable doubt. You could testify or not testify. You understand those rights?
Yes, sir.
By entering the plea, you're not going to exercise those rights.
No, sir.
You're under the care of a doctor for any mental health condition now?
No, sir. No, sir, not at the moment.
You're on drugs or medication at the moment?
No, sir.
Do you understand what's going on?
Yes, sir, I do.
How far did you get in school?
Graduated high school.
I find you freely and intelligently entering this plea with a lawyer who you say is with whom you are satisfied. I'm going to accept the plea, withhold adjudication of guilt, and impose 2 days in the Orange County Jail with credit for the 2 days that you've previously served. Order your release today, assuming nothing else is holding you. Is that, you understood that was what was going to happen?
Yes, sir.
All right. There'll be some court costs associated with this. You have a year to make payment on those court costs to pay them off. Understand that?
Yes, sir.
You have the right to appeal. If you take an appeal, it must be in writing. If you can't afford a lawyer, one will be appointed for you. Understand?
Yes, sir.
Thank you. You're excused.
You're all set. Good luck. Thank you.
Kevin Williams? Yes, sir. Same state?
Yes, Your Honor.
All right, Mr. Williams, the state is willing to let you resolve this case today. If you want to enter a plea to time served, you get out. You can, there's a bond on your case of $500 in 2 charges for a total of $1,000. You can enter a plea?
I believe so, Your Honor. Yes, yes, Your Honor.
Okay. Yes. You're good. You only been doing this a couple days, right? You picked it all up that fast? Oh, you have. I've seen you down. Thank you so much, sir.
Oh, man.
All right, sir, raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Tell me your full name.
Kevin M. Williams.
All right, Mr. Williams, you're charged with camping and urinating or defecating in public. Both of those are city ordinance violations. They're misdemeanors. Your lawyer tells me that you want to enter a no contest plea to those charges with the understanding that I'll accept your plea, impose time served of 2 days? Time served of 2 days, which means unless you're being held on something else, you'll be released today. Is that what you want to do?
Yes.
All right, sir, do you understand that you have a right to a trial?
Yes.
And that you have the right to have a lawyer represent you at trial? During that trial,
Yes.
you'd have the right to have the jury or a fact finder decide that you were guilty beyond a reasonable doubt before any sanctions could be entered?
Yes.
You'd have the right to compel witnesses by way of subpoena and to have you or your lawyer cross-examine the witnesses called against you.
Yes.
By entering a plea, you're giving up those rights. You understand that?
Yes.
Are you under the influence of any drugs or alcohol as you stand here today?
No.
You suffer from any mental health issues as you stand here today? You satisfied with your lawyer's, the way your lawyer resolved this case? All right, sir. I'll accept your plea, impose the sentence agreed upon, which is the withhold of adjudication. Credit for time served of 2 days in both counts to run concurrent. There are some court costs associated with the case. I'll give you a year to pay those off. Paperwork will have the exact amount on it. Do you understand that?
Yes.
All right. You have 30 days to file a notice of appeal in writing. If you intend to appeal, it must be in writing. If you can't afford a lawyer, one will be appointed for you. Do you understand?
Yes.
All right, thank you, sir. Good luck to you. Yep. What is all this?
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.